Quenton Lawrence Height, Brett Sweeney for the state. The defendant appears in person and per se. Mr. Height, count one, you're charged with driving without your license and possession when demanded, an unclassified misdemeanor, a sentence up to 30 days and $500 maximum fines. And count two, driving without registration or tag, an unclassified misdemeanor, up to $2,500 in fines and 30 days to 6 months. Do you want to, well, how do you want to proceed, sir?
Good morning, Your Honor. My name is Quenton Lawrence Height, the accused in this matter. I'd like to briefly state for the record that I have made good faith efforts to meet with the prosecution prior to today's proceedings. I called the Butler County Attorney's Office twice and had in-person meeting times set up to discuss a dismissal agreement with the intention to obtain and present a valid Kansas driver's license, insurance, and registration on the car involved. Unfortunately, I was rescheduled on both occasions. The most recent meeting was scheduled for yesterday afternoon, but I was informed that Jared Regier had jury duty this week. At 7:55 a.m. this morning, I sent an email proposing a dismissal agreement. I also called the office at 8:19 a.m. to speak with Mr. Jared and his team, but unfortunately, Jared and both Brett Sweeney were unavailable. With that said, I am not sure if Mr. Sweeney was made aware of my meeting attempts, emails, or phone calls this morning by the receptionist in the county attorney's office this morning. Additionally, I do have a meeting set in person for August 7th at 3 p.m. for the discussion of the same matter. Given these circumstances, I request a continuance. I believe with a short amount of additional time, we may be able to resolve this matter efficiently without burdening the court. I'm also available to meet with the prosecution in person over the phone after court today or before 1 p.m. tomorrow. I'm also available to register my car on the same timeline to satisfy the diversion agreement. I respectfully ask the court for a brief continuance so that I may pursue this resolution opportunity directly with the county attorney's office. Thank you, Your Honor, and I yield.
All right. So are you waiving your right to counsel then and representing yourself?
I am presenting myself today.
And you understand that you can hire any attorney, and if you cannot afford to hire an attorney, you can apply for court appointed and see if you qualify?
I do comprehend, yes.
Okay. Would you wish to proceed on your own behalf? Is anyone making you give up your right to an attorney?
No one.
All right. Well, I'm showing that you have knowingly and voluntarily waived your right to counsel so you can represent yourself. Put that, please, in the journal entry and docket notes. Next, have you looked online at the diversion program to see if you are interested in that?
I have not had an opportunity to do so. As I had stated, I was hoping to discuss the terms in person with Mr. Regier or hopefully this morning, Mr. Sweeney, but they were both unavailable. So at this time, I have not reviewed the terms, no.
Looks like you have some pending cases in about at least 2 other counties. Does that sound right?
I would like to say that those matters are separate. I don't know if that is true or correct.
Well, 2 of them are in Butler County. It looks like one in Sedgwick. Let me see when the court date is so we can maybe put them together.
In Your Honor, I was going to mention that this case has actually already been set on Chief Judge Ricky's docket for another hearing, August 25th at 3 p.m.
May I ask, Destiny, are you talking in regards to the current matter that we were discussing today, the 1215?
Yes, it's regarding this case. It's going to be set with the other case as well, though.
Interesting.
Right.
Okay.
Okay, so is Judge Ricky reassigning these 2 cases to himself?
He is, Your Honor.
Okay. Is there a felony case, Mr. Height?
I'm sorry, say again, please.
Well, I was just curious why Judge Ricky would snag 2 misdemeanors out of the group here. Do you have a felony case pending with Judge Ricky?
Not that I'm aware of, and as of my first hearing on the other aforementioned matter, he said he would not be lumping these 2 together. So this is news to me. I was not made aware of this. And I also did state that my preference would be to have them separate, and he agreed as such. So this is interesting to me.
Mr. Sweeney, any information you might be able to have or like to shed on this?
Just kind of hearsay, Your Honor. Mr. Regier, prepping me for today's docket, did talk to me about this case and say that maybe he had a meeting coming up with the defendant, but he did mention that Judge Rickey took one of the cases, but my understanding in speaking with Mr. Regier is that the other case was to remain
Quenton Height refuses an attorney and tries to bypass the court by negotiating directly
all of
with
them
the
are
prosecutor.
misdemeanors, of course,
But the
including
judge
this
isn't
one.
buying it.
But
The real
my
twist
understanding
comes
is
when
that
the
he
court
was
discovers
retaining
multiple
one of the
pending
misdemeanors,
cases and
but this
transfers
traffic
everything
case
to another
was to
judge.
remain down here.
Height objects,
I could
but
be
the court
incorrect, but
controls the
that's what I
docket.
understood in speaking
The
with him.
result. No
And I believe that
conviction
was what was
today,
previously
just a
stated. I do
continuance.
have a
The
note as
sovereign
well
citizen
on
walks
this
out,
case in the
but his
25
legal
TR
battle is far from
1215
over.
from
Is that the other case was to remain in front of Your Honor. So all of them are misdemeanors, of course, including this one. But my understanding is that he was retaining one of the misdemeanors, but this traffic case was to remain down here. I could be incorrect, but that's what I understood in speaking with him.
And I believe that was what was previously stated. I do have a note as well on this case in the 25 TR 1215 from Judge Rickey's assistant, stating that it's to be moved and set for August 25th at 3 p.m.
Okay.
All right, Mr. Height, I'm not sure what Judge Rickey has in mind, but I trust he does, beyond any doubt. So we're going to move this case to Judge Rickey's docket, August 25th at 2:30.
Okay.
And license and registration. No clue, but I have plenty of cases to object. I'm grateful for any help. Let's see.
I would like to note on the record that it is my preference to keep these separate. Just wanted to make that heard.
That will be noted. Please note that on the record. Two unclassified, you don't have to make bond in that case. So I'm going to order that you reappear at the date and time given before Judge Rickey. Did he say whether you wanted that by Zoom or in person?
My request would be to be in person. And also I did want to state one more further thing for the record that the judge had during, like I had mentioned earlier, but wanted to make sure the record reflected that he was not planning to put them together. So just making that available. Thank you.
Okay. All right. Well, you may go, sir. Choose from these proceedings. Just make sure you reappear at the date and time given.
Okay. And one more time for me, please. The date.
August 25th at 2:30. Didn't you say, Destiny?
I show at 3 p.m., Your Honor, but
Okay.
August 25th nonetheless.
August 25th, 3 p.m. And did he say again in person, or did he specify Zoom or in person?
I show that the other case is set by Zoom, so I would presume that both will be set by Zoom, Your Honor.
Okay. You might call back close to the date and confirm that that's right, sir.
Okay.
If you want a court-appointed attorney, you need to turn in an application for one. Do you want an attorney?
I do not.
Okay. All right.
This courtroom hearing wasn't filled with shouting, dramatic outbursts, or shocking confrontations. Instead, it showed something that can be just as important in the justice system: procedure, patience, and persistence. From the very beginning, the defendant tried to explain that he had made multiple attempts to resolve the matter directly with the prosecutor's office. He argued that he was willing to cooperate, obtain the necessary documents, and work toward a resolution without consuming additional court resources. His request was simple: give him a little more time to continue those discussions. The judge listened carefully, asked the necessary questions, and ensured that the defendant understood his right to legal representation before allowing him to proceed on his own. As the hearing continued, it became clear that the focus of the case was no longer just about a driver's license, registration, or traffic violations. It became about how the legal process itself would move forward. One of the most interesting moments came when the court revealed that another judge had decided to take over the case and place it alongside another pending matter. The defendant objected, stating that he preferred the cases remain separate, but ultimately the court made it clear that the decision was no longer his to make. This hearing serves as a reminder that court proceedings are often about much more than the original charge. Legal strategy, scheduling decisions, jurisdiction, and courtroom procedure can all play a major role in determining what happens next. Whether you agree with the defendant's approach or not, he remained respectful, organized, and determined to make his position heard. In the end, however, the court's decision stood, and the case moved forward on the court's terms rather than his own. The question now is simple. Was the defendant taking reasonable steps to resolve the issue, or was the court right to move the case forward without further delay? Let us know your thoughts in the comments below.